Okay, so they want to go forward.
Name-
Miss Piscucci's to leave the property forthwith. She's a threat to your safety, her and your granddaughter.
Okay.
Ma'am, you're to vacate the property forthwith. I find that you present a risk to these two individuals. It is unsafe for you to be at the property. She's to leave forthwith. I'm signing an immediate writ for her eviction.
Yeah, I'm sure you are.
I am. And you know what else? I'm going to hold you in contempt if you say one more word. All right, Mr. Chandler's here. Miss Piscucci's here. Can you unmute? This is 2501036. Leon Chandler and Renee Chandler versus Kristen Piscucci. Mr. Chandler, can you tell me your name? You're muted. We'll get you going.
Yeah. This one apparently has.
Ma'am, you have to get off the phone.
You're good.
Like I'm literally, you're in a courtroom. All right.
Guys, I'm on the phone with my grandmother, the homeowner.
Okay. Which one of you is Kristen Piscucci?
Me.
You are. Okay.
Yeah.
All right, Mr. Chandler's here. Mr. Chandler, tell me your first and last name. You need to unmute. I'm asking you to unmute. Got it? Good. Yep, tell me your first and last name.
Leon Chandler.
All right, and Ms. Piscucci, can you tell me your name? I'm sorry if I'm butchering your last name.
It's okay. It's Chris Piscucci.
All right, so we're here today. There was a dismissal that was filed, and then there was a motion to set aside the dismissal. So we're here today. Where is Renee Chandler? She's
on the phone. That's actually who the person next to me is talking to.
All right, well, where's Renee Chandler at, Mr. Chandler?
She's in the house.
No, wait 1 second. Mr. Chandler, where's Renee Chandler?
She's in the other room. You want me to get her?
Yeah, you two both have to come into court. It's both of your motion. So she doesn't need to be on the phone with the other party. She needs to be in the courtroom.
Okay. Just a second.
Yeah, now's your chance to speak up.
That phone can be hung up. She's coming in.
Yep. She's coming in right now.
I'm not gonna.
Yeah.
All right, if you can just sit by her, Mr. Chandler, so I can see you both.
Okay.
All right, ma'am, can you tell me your first and last name?
Renee Chandler.
All right, thank you. All right, so we had a motion that was filed. Originally, there was a demand for possession of the house. It was a termination of tenancy, essentially, and then it was set aside. The case was dismissed.
Right.
And we had notice of dismissal that was signed by Renee Chandler. And then we had a motion to set aside the dismissal. So Ms. Chandler, you and Mr. Chandler, do the two of you, can you raise your right hands? Both of you? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Do the two of you own a home together?
Yes.
All right. And where is the home that you own? Is that the one on Holland?
Yes, ma'am.
Do you also own a home on Tulane?
No.
No.
Okay. So the home that you own and that is that issue in this case is the property at Holland.
Right.
Okay. And does Miss Piscucci still reside there?
Yes.
At this moment.
Okay,
Yeah.
so she's still living there. And so this motion to dismiss the case was filed. Mr. and Mrs. Chandler, is it your position at this time that you want to go forward with the termination of tenancy?
Yes.
Ma'am?
Yeah.
Okay, so they want to go forward.
Mamie,
No.
Don't.
Mammy, she's asking if you want to evict us. You're lying. We have you on video. We have you on recording. You know that.
Ma'am, Miss Gucci, you're in a courtroom. Okay?
I'm sorry.
Okay, act like it. Miss Chandler. So this suit was originally filed. I'm understanding that this is your granddaughter. Is that correct?
Yes.
All right. Are you feeling
Oh, no,
pressure?
I'm sorry. Excuse me, Judge.
Yes?
No, it's not my granddaughter. It is
My granddaughter's friend.
my granddaughter's friend.
All right, Miss Pascucci. So she's not a family member. She's
No.
just someone that's residing at the location with your granddaughter.
Yes.
What's your granddaughter's name?
Logan Renee McNutt.
All right. Now, Mrs. and Mr. Chandler, is it your testimony to this court that you want Miss Pascucci to vacate the residence?
Yes.
Ma'am?
That's
Oh,
my
yeah.
Shh. Who is talking back there?
Here,
She not, Miss Chandler, would you like
Yeah.
Miss Pascucci to leave the property?
Yes.
Okay, Miss Pascucci, you don't have an ownership interest. You're there as an at-will, tenant, and they're asking for you to vacate the property.
Yes, I didn't know that they were asking me to vacate the property. They actually never asked me to vacate the property. Eviction notices.
Well, they did because they filed these notices that there were threats against family members. It was causing havoc. And that it's happened, on more than one occasion.
Excuse me, Miss. I'm not sure what your name is. I actually stay outside.
My name is
Yeah.
Judge Shackelford.
Judge
I'm
Jackson.
the judge.
Okay.
Okay.
Yes, ma'am. I stay actually outside on their property in a trailer because I'm actually homeless. I'm trying to find somewhere to go. They know that. That's the only reason that I'm actually here. I don't even really go in their house unless it's to shower or to cook. But I actually bought a burner from Family Dollar to be able to cook my food out here. So I don't have to use the bathroom in the house either. I bought a bucket with some trash bags. So I don't even have to go in their house.
I know, but you can't, Miss Pascucci. I'm sympathetic to your
I
your circumstances, but that's their property.
I
And it's
understand.
their home. And if they don't want you there, you
Ma'am-
can't stay there.
Renee does. Leon does not. I have video voice recordings of her saying that.
I don't care. She's in court. She's under oath. She's advised me that she wants you to vacate the
She's lying
property.
under oath, ma'am.
Okay, you have to vacate the property. You have 10 days to vacate.
More than that, I don't have a job right now. I need
All
at least.
right, ma'am, this is the law.
I
And
understand.
I don't, okay, well, I want you to understand that's the law. You have 10 days. I can tell why they want you out because you think you can
On
talk
top
over
of it, I'm
people
pregnant. This causes
and yell.
stress.
You have 10 days to vacate the property. Mr. and Mrs. Chandler, you are to call
That's not
police.
fair. That is not right.
You are to call police if she tries to vacate, or if she tries to enter your premises, if she tries to come in your home, and if she does not leave in 10 days, you come up to the court and there is a form that you get for a writ of eviction, and our court officers will come and remove her and all of her belongings from the property.
Okay,
But
Judge.
Mr. and Mrs. Chandler, if she comes near you or her granddaughter attempts to convince you otherwise, the two of you are to call the police forthwith. You're to call the police. They're not to harass you. You have no obligation to keep anyone on your property that you're not comfortable or safe with. She's to remove all of
And
her
it's just
property.
him. He steals from her and everything else.
She's to leave your property, and you're to contact law enforcement if she comes. Do you understand me, Mr. and Mrs. Chandler?
Yes.
Okay, I'm signing it. You have 10 days. You can get your writ for eviction in 10 days.
This is so not fair.
You know
Right.
what, Miss Pascucci, do you pay rent even? You want to just stay on someone's property for free, and you think that's not fair?
It's
That they want you
not even
out?
it. That's not even it, ma'am.
All right, I think she might be a risk to your safety, Mr. and Mrs. Chandler. She clearly cannot control herself. The allegations, Mr. Chandler,
You won't
Mrs.
even let me
Chandler,
speak.
who's that? Who is that behind you? Mr. and Mrs. Chandler, who is that at the door behind you?
That's
Your
my,
granddaughter?
no.
Yeah.
My granddaughter came in the bedroom just now. And she's
All right, and
arguing
is she,
with my,
Miss Pascucci's to leave the property forthwith. She's a threat to your safety, her and your granddaughter.
okay,
Ma'am, you're to vacate the property forthwith. I find that you present a risk to these two individuals. It is unsafe
I'm not
for
even
you
in
to
the
be at the
house.
property. She's to leave forthwith. I'm signing an immediate writ for her eviction.
Yeah, I'm sure you are.
I am. And you know what else? I'm going to hold you in contempt if you say one more word. Mr. and Mrs. Chandler, do you need to have your granddaughter vacated?
no, we can handle my granddaughter.
Okay. She's to leave the property immediately. I'll sign a writ now.
Okay,
Okay?
All right.
If she comes in your home, if she makes any threats towards you, if she does not leave forthwith, you're to call the police.
okay.
Are we clear?
Yes, ma'am.
All right, she's to vacate forthwith. I'll have the clerk bring up paperwork. Mr. and Mrs. Chandler, you can come up to the court and get your writ today. I need to fill that out. Okay, come on up to the court.
Okay, thank you.
All right, thank you. Okay. Is that her screaming in the background?
Yeah, it's okay. That's my granddaughter.
Okay. It's just your granddaughter screaming. It's not
Right.
the other individual?
No, the other individual is not in the house.
All right. What do you do if she comes in the house?
We ask her to leave or call the police.
And yes, sir. All right, you're all set. Have a good day.
Okay, thank you, Judge.
Yeah, all right. Mr. and Mrs. Chandler, are there any further issues? Has she shown up at your house? I can't hear you. You're muted.
Just my granddaughter and she's gone.
Okay, so you're all set?
Yeah, we're all set.
If you feel unsafe, you know what you're supposed to do, but you can disconnect yep, tell them to leave, call the police, but you're all set for the day. You're free to leave, court.
Okay, thank you.
How do we
Disconnect to? Or will you?
I'll disconnect you. Don't worry. I just was letting you hang out to see if they showed up, but I'll
Yeah.
remove you now. And if you need the police, call them. Okay.
Okay, and that there's an attorney here that's present to represent you. You understand that?
I don't want no,
It's a yes or no answer,
I
ma'am.
don't want the state of Michigan being paid.
Excuse me.
I have got,
Excuse
I
me.
have government corruption reported. I have government corruption reported.
What's your name? I'm just going all, okay, that's fine. All right, which one do we have there, Jerry? Is that Ms. Whitmer?
That's correct, Judge.
Yes.
Okay. All right. All right, we are going on the record in the matter of the state of Michigan versus Tamara Whitmer. 25674. Detective, your name for the record, please.
Detective Chelsea Haskin.
All right, I'm going to ask you to please raise your right hand. Do you solemnly swear from the testimony you're about to give this matter to be the truth, the whole truth, and nothing but the truth?
Do.
I'm sorry?
I do.
Thank you. And please proceed on the warrant.
On May 14th, 2025 at 2:48 p.m., Wyandotte officers Cox, Barwig, O'Meara, and Perez were dispatched to the area of Fort Street and Eureka Road due to a female sitting in the grass on the side of the road looking out of it. Caller stated the female looked beat up. Upon arrival, Officer Cox spoke with a female, later identified as Tamara Whitmer. Officer Cox observed Whitmer to be highly intoxicated, with extremely slurred speech and an open pint can of MXD margarita sitting beside her. Whitmer was asked about the open alcohol and responded, "Yeah, what are you going to do about it?" Whitmer became disorderly with officers, eventually producing a can of pepper spray from her backpack and pointing it at officers. Whitmer was advised several times to put the pepper spray away. Officers were able to gain control of Whitmer, who sprayed Officer Cox and Barwig on the hands with the back off dog repellent spray. It took several Wyandotte officers to place Whitmer under arrest.
All right. Upon examination, I find the offense charge is committed, probable cause exists to believe defendant committed that offense. And counsel, good morning. Your appearance, please.
Good morning, Judge. Attorney Corey Westmoreland appearing on behalf of Ms. Whitmer. Your Honor, at this time, I did have an opportunity to speak with Ms. Whitmer, and she's electing to waive her right to have counsel represent her at this time.
Okay. Well, okay, Ms. Whitmer, please step forward at the podium. All right, Ms. Whitmer, you do understand that you are in court on criminal charges, correct?
Yes,
And that you do have, are here on very serious criminal charges, and that you do have the right to have an attorney represent you at all critical stages of the process. You understand that?
it's exaggeration fraud.
Ma'am?
It's exaggeration fraud.
Excuse me, stop talking. I just asked for a simple yes or no answer. Do you understand that you do have the right to have an attorney represent you at all critical stages of the criminal process?
Yes, I do.
Okay. And that there's an attorney here that's present to represent you? You understand that?
I don't want no,
It's a yes or no answer,
I
ma'am.
don't want the state of Michigan being paid.
Excuse me.
I
Excuse
have
me.
government corruption reported.
Ms. Whitmer, I am directing you to answer my question, yes or no. You
I said
understand?
no, I do not want him.
That wasn't my question. My question was, you understand that there is an attorney that's here to represent you today. Do you understand that?
I do not want him.
It's yes or no. Do you understand there's an attorney to represent you today?
No, because he shouldn't be there. He told no.
Ma'am, I just want you to understand or to indicate whether you
I
understand.
do understand I don't want that attorney. I do not want him.
Stop interrupting me. I just, for the record, want to hear you say that you do or you do not understand that there is an attorney that is here to represent you.
And I don't want him.
Okay, so you do understand that you do have the availability of an attorney.
And I waived it.
Okay, so the court's going to indicate for the record that Ms. Whitmer does understand that there is an attorney that's here to represent her today, and she is choosing to waive that right to representation. Ma'am, I'm not going to ask you about the charges. I'm asking if you want the court to read the charges, or do you want to waive the formal reading of the charges?
You can read the charges.
All right. The court has before it a complaint that alleges on May 14th, 2025 in the area of 4th Street in Eureka in the city of Wyandotte that Ms. Whitmer did assault, batter, wound, resist, obstruct, oppose, or endanger Kate Barwig and or Kyle Cox, a police officer in the city with the Wyandotte Police Department, that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D(1). This is a felony matter. The maximum penalty upon conviction is not more than 2 years in state prison and or $2,000 fine. Consecutive sentence may be imposed under statute if the assault was committed at a place of confinement or under MCL 750.81D6 for another violation arising from the same transaction. Do you understand your charges?
Yes, I do.
All right. For this matter, the court's going to enter a plea of not guilty for purposes of the arraignment. You have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And you've chosen to waive your right to representation, correct?
Correct.
All right, the court will note the defendant has waived the right to representation for today's proceedings. However, the court is signing an order for appointment of attorney. In the event you choose to have an attorney moving forward, the court has to sign that, so the court is signing that. And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right. The court's going to schedule this matter for probable cause conference on May 29th
9:45.
at 9:45 a.m. Ma'am, you also have a matter that you failed to appear for back in May of 2024. And so for that matter, we're going to conduct the arraignment on that matter as well. And that's the City of Riverview versus Tamara Whitmer, 24348. And ma'am, you're also waiving your right to an attorney for this matter as well?
Yes.
All right, the court will note that it's alleged that March 31st, 2024, in the area of 17504 4th Street, that you did commit a larceny.
Not guilty.
Ma'am, I'm just informing you of what the charges are and the maximum penalty. Where it's alleged that you took
Not
items,
guilty.
and you took items out of an apartment washer and dryer area. The maximum penalty upon conviction is not more than 93 days jail and or $500 fine. The complaint also alleges on the same date and location that you did behave in a disorderly fashion in public. That's also a 93-day misdemeanor. The maximum penalty upon, that's also a misdemeanor. The maximum penalty upon conviction is not more than 93 days jail and or a $500 fine. And
I'm pleading not guilty.
I understand that, ma'am. I understand that. The court's going to schedule enter a plea of not guilty.
May I speak?
Excuse me, on your behalf, schedule this matter for pre-trial on June 2nd.
Because it's over the 2 weeks.
So May 19th, Monday. May 19th
At 9:45.
at 9:45 a.m. Ma'am, there's a document for attorney waiver that you're going to need to fill out before you are done today. Now, I also understand, let's talk about body now. Where do you live?
I'm homeless.
Okay, and how long have you been homeless, ma'am?
Off and on since 2020.
Okay, why is that? Are you unable to work?
I'm harassed over a probate case that is already closed since 23.
What do you mean harassed from a probate case?
Harassed, there's a lot of, schemes going on. My attorney, gave us a different personal rep, and she, verified it wasn't canceled. And then someone behind my back and canceled it. There's a lot of fraud going on.
Okay, and, it's a probate case. Is that because you're a beneficiary of something, or there's a probate case, regarding a petition for your treatment?
No. Treatment for what?
I don't know. I don't know if you have medical issues that you need assistance
No,
with.
no, I don't. I don't like being lied to. I don't like liars.
Okay. All right, well. You previously failed to appear in court here, ma'am. Why is that?
What was that?
You previously failed to appear in court here. Why is that?
I either didn't have a phone or didn't know the date and time of the court date.
Okay, well, you also have a failure to appear in 2023 from Southgate. You didn't appear
Right, I'm
in
still homeless.
and resisting an officer.
That was a lie too.
Okay, well, yeah, even, let me just say this. If you feel as though it's not accurate, you still need to appear in court. Same
Okay.
with the 33rd District Court. You have another charge of resisting, hinder, obstructing an officer, and you did not appear for a show cause hearing in that matter as well.
Which one is that regarding?
That's from, so that court is in Woodhaven regarding.
Oh, that was already taken care of. That was already taken care of. So was Southgate.
Okay, and
I repleted, I did police harassment already, discrimination. They're just trying to gain money for the state.
okay, well, ma'am, just so you're aware, if you have an attorney,
But they have that.
Stop interrupting me. Stop interrupting me when I'm talking. Number one, you can't hear what I'm saying. Number two, we're not getting an accurate record. So stop interrupting me when I'm talking. I was telling you, ma'am, that if you choose to have an attorney represent you, there isn't money going to the state for the attorney to represent you. I just want you to be aware of that because you made that comment a number of times.
I would not like an attorney, but thank you.
Are you under the treatment of any medical professional?
No.
Are you currently on probation or parole anywhere, ma'am?
No.
If you were to test, what's in your system?
Just alcohol from the other day, if it's still there. I'm willing to test. I have nothing to hide.
Okay. Then do you have any children that you support or otherwise?
I have a son who's 22, but he's working and whatnot.
Okay, given the fact that Ms. Whitmer, given a number of factors, number one, the danger to the community, the danger to the officers with the pepper spray possession and discharge, that's been alleged, as well as the failure of Ms. Whitmer to appear in court previously in the other matters, the court's going to order a $10,000, 10% bond on the 25674 matter. I'm sorry, Detective, would you like to address bond?
No, Your Honor.
As to the 24348 matter, the court's going to set this for as a $5,000 10% bond. These are the following bond conditions, ma'am. You are not to possess any firearms or weapons. That includes any weapons that you are not authorized to carry, such as pepper spray or otherwise. Do you have any weapons, ma'am?
No.
You are not to be contacted with Ms.
I have a
Waleed.
pair of scissors, I'm sorry.
I'm sorry?
I cut my own hair, I do have scissors on me.
Where are those?
Those in my backpack.
Okay. And so then the court's going to also order you on the other matter not to have any contact with Natalie Waleed to return to the Huntington Apartments from Riverview. Do you know Ms. Waleed?
What was it called?
Do you know Ms. Waleed?
No.
Okay, then there won't be any problem. You're not to possess or consume any alcohol or drugs that are not prescribed, that's on both matters. And you're not to be released without a GPS tether to the Wayne County Jail. And we will see you back on Monday on the one matter and on the 29th on the following matter. Thank you. Let's go off the record for a moment.
And where are we on this case, folks?
Your Honor, we've had a few hearings on this. The court had set this for a trial at this point based on the affirmative defenses that were asserted in the matter. I believe there's no triable issue. If you look at the answer filed by Ms. Kingley in the matter, she admits to the non-payment of rent. She admits to the fact that there are damages to the unit. The court is aware there were police reports filed and attached with the complaint that the damages were the result of the defendant herself breaking the windows, refusing access. The landlord is now going to be outside of the certificate of occupancy that was issued because repairs can't be made. They can't get access to the property. It continues to deteriorate. As a result, there's a broken window, broken doors on the interior, broken doors on the exterior. We filed a notice to have this terminated as a result of the health and safety hazard as well as the non-payment of rent, and we'd be asking for a judgment at this time.
Response.
I have it prepared here. I will pull it up. Okay, this was what I received from attorney with the legal aid, Tracy Jensen. And there are several issues at hand, including procedural defenses. In regards to my written statement and the statements made by Attorney Babnick, the property is not damaged. The pictures that the landlord included, I have countered and included pictures of the house in its current condition. The house was inspected by the Ypsilanti Building Code, Miss Jamaica Berry, in October. In October, I also filed a formal complaint with the city of Ypsilanti through the C-Click Fix notification system, a governmental agency, of the issues with the habitability of the home. I have filed a case with the Fair Housing Administration. There are many things that we could focus on. I would like to focus on the fact that I was denied a disabled parking spot. And according to Michigan Legislature Section 600, and that is 600.5720, says that if it's an alleged termination was intended primarily as a penalty for the defendant's attempt to secure or enforce rights under the lease or agreement or under laws of state, governmental subdivision, or United States, they denied my handicap parking. I filed several complaints at the city level, and I'm defending myself here. The alleged termination, Part B, was intended primarily as a penalty for the defendant's complaint to the governmental authority with a report of the plaintiff's violation of the health or safety code or ordinance. The allegations made by the landlord I wanted to bring in a third-party perspective. So I contacted the Ypsilanti Building Code Department. Mr. Maka came out and did an inspection and found 12 violations on the landlords, at the landlord's responsibility. In regards to the statement by Attorney Bagnick that they have not been allowed to access the unit, that is so false. Her husband, Mitch Carrick, busted down the door, and I was not able to secure the unit.
This isn't the time for me to receive.
I think there are tribal issues, and I can.
Thank you.
Yes,
That's
sir.
all you needed to tell me. And when I look at that, then what I'm going to do is I'm going to do two things today. I'm going to set it for a final settlement conference on this. We'll hash out specifically what issues are going to be litigated. The parties are going to need to be ready to go to trial when I set the trial date thereafter. All right. I'm also going to order regarding escrow, and I'm just going to say this to you, Ms. Kingsley, that you coming into court and posting escrow in $1 bills, this court views as just harassing my clerks and making my clerks go through that process. It is something that I'm not going to tolerate. There is no reason why you have to bring single dollar bills in. You did that when you paid the $111.11. You also did that when you paid $444.44, which my clerks had to count out. You also did that when you paid today the $666.66. So on my own motion, I'm going to order that as you post escrow, that you may only post escrow in denominations of U.S. currency, not less than $10 bills. It is further ordered that from you on this case, because of your abuse of the process, and my clerk's office are ordered that they are ordered to accept no $1 or $5 denominations of U.S. currency for you for the purposes of escrow. And I have signed that order. We will present that to both parties. See everybody on March 19th.
Quickly, can the court, what's the registry of the court as far as the escrow?
There is a $111.11 posted by our records. It was posted on January 8th, 2024. On January 10th, 2024, there was posted $780. On January 22nd, 2024, there was posted $1.11. On February 5th, 2024, there was posted $444.44. And I think today, correct?
Yes.
Today, there was posted $666.66.
If I may, Your Honor,
Go ahead.
I just want to establish that I paid the full amount through February, and there is a balance ready for March. This is not an issue of paying the rent.
My issue isn't with whether or not you pay rent. It isn't anything like that. You will not be trying to bring singles in, trying to make some point to my clerks. They have nothing to do with whatever the issues are here. They are here trying to serve the public. You will not hand them $600 worth of $1 bills for them to count out. It just won't happen. And I've issued that order.
Would you like any response to that, or we can just move forward?
You can make whatever response you want. I'm just telling you, don't bring any singles in here trying to post escrow. Don't bring any $5 bills trying to post escrow. $10 or higher.
Understood.
That's it.
Going forward, Your Honor.
Is there an adjourned date, Your Honor? I'm sorry, I didn't hear.
March 19th, 2024, 9 a.m. in person.
Your Honor, if I may continue,
Thank you, Your Honor.
if I may.
Go ahead.
Right, so I did confirm with the clerk that all U.S. accept policy does not.
No longer on this case. That is my order. Thank you. I'm done.
We are done. Thank you, Your Honor. I understand. March 19th at what time?
9 a.m.
Thank you, Your Honor. Have a wonderful afternoon.
I will do. You do the same.
I will do my best. I am grateful.
How are you, sir? What's your name?
Harold.
Emily didn't want your case called either.
Yeah.
No, I don't know. I don't know what that's about. I don't know what you did to her.
One of my old attorneys, Fred McDonald, told me don't pay nobody $1 bills.
Fred McDonald was my former partner. Yes.
Money paid.
All right, where are we on this case?
Your Honor, I'm pleased to report Mr. Robertson and I met, and we've agreed to a conditional dismissal in this case. Rent to return in the amount of 2548, court costs of 160. That number, by the way, is through the end of March.
Okay.
160 in court costs for a total of 2708. Mr. Robertson's going to pay 2558 by March 4th and the balance of 160 by April 5th. I did explain to him that partial payment would stay an issue for writ, and we went over MCR 4.201J.
Okay. Only thing I want to change, Daddy, Your Honor, I'm on fixed income. And if the money don't come on the 4th, I want to make sure that I can pay it on the 5th. Instead of that being the 4th, the 5th.
So
that's fine with us.
So so you want this changed to March 5th?
Yeah, yes, March 5th.
So when does your check come in?
So I get one on the 1st and one the 3rd.
Got it.
Yeah.
Okay, so it's that first payment.
Correct.
No problem with changing it to the
No, sir.
All right. I'm gonna make that correction. Anything else, sir?
No.
All right.
I just want to pay him in $1 bill.
Please don't.
Okay.
You don't understand what a sore spot that is. All right.
You guys should be disinfect the $1 bills. I'm telling you what.
No, I mean, I didn't have to count it. So
Okay.
I had a whole lot of people telling me they did.
Okay.
So, all right. So, sir, any other questions you have regarding this?
And that last payment for the 160 supposed to be when?
Yeah, that's April 5th.
April 4,
which would be that Friday. So it's March 5th and April 5th.
Okay.
So it's 160.
Okay.
All right. You had 3 business days to think about this from the date of my signing. If you believe that there's some legal reason, some confusion as to your rights or some right you haven't asserted, you'd have to file a motion with the court within that time frame to set this aside. Do you understand that, sir?
Okay, then that's 3 working days. That would be like
3 business days.
3 business. Okay.
I don't think you should be filing it, but you do have that option. Doesn't mean that I'd grant that motion.
All right.
Understand that? All right. Thank you. I'll mark this conditional dismissed. Thank you.
Thank you.
Angel Tierra Murkerson, file number 25B148321. And it should be Officer Paul. Good morning. How are you?
Good morning, Your Honor.
Your name?
Officer Paul, Brownstown Township.
Where is Ms. Murkerson? You're going to have to start your video, please. Bottom left-hand corner of your screen.
Yes, Your Honor. Angel Murkerson.
Okay, stay right there. Who are all these people around you?
Oh, I'm at work.
So I want to just see you and we'll go from there, okay? The officer is here. He's ready to have the hearing. Do you still wish to proceed to the hearing, ma'am?
Yes.
I'm going to ask you, officer, and you, ma'am, both to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Officer?
I do.
Ms. Murkerson?
Yes, I do.
Okay, go ahead, officer.
On March 18th of this year at approximately 9:03 a.m., I was on patrol in Brownstown Township, working in OHSP seatbelt detail. At that time, I observed Ms. Murkerson operating her motor vehicle wearing her seatbelt underneath her armpit and proper use of her seatbelt, and she was cited for the same.
Any questions of him?
You say questions. Are you asking me, Your Honor?
Yeah, do you have any questions of him, of the officer?
No, my only question was, my concern was that I had on my seatbelt and I told him me reaching for my beverage, by me being short, my seatbelt naturally wants to come here. And if it's over my shoulder, when I go to reach for my drink, it's in the way. So I thought it would be just a warning. I'm like, I got a good driving record. You know, I did have my seatbelt on, but that was my only question.
But you can't wear it like that though, ma'am.
I don't wear it like that. I was just grabbing my beverage and I literally had put my seatbelt under my arm. Like I said, I felt personally, this is me, I'm not saying that it's right, but I felt like that should have just been a warning, being that I did have my seatbelt on when there's people that don't wear their seatbelts at all.
Well, that's not a defense. I mean, the fact that some people choose to violate laws.
But my defense is I was practicing the law. It's just that I did, as he said, okay, but it wasn't on properly. It was buckled. If I had had it holding it with my arm, but it really wasn't buckled, then I feel like that would have been okay, that's a violation. I didn't know that me putting it under my arm to reach for my beverage would cause me to get a ticket. I had no idea. So to me, I didn't see them give people warnings for lesser things. My seatbelt was buckled up. It just wasn't across my shoulder when he.
You're not wearing it properly, ma'am. That's not wearing it properly.
Your Honor, if I may, speak, she did receive 2 verbal warnings, one for her plate or vehicle showing no insurance on it, and she received a warning for a tinted license plate cover.
My vehicle had insurance from the date that you pulled me over before then.
Wait, let him finish.
Oh, okay, okay, no problem.
Wait.
So again, when I ran the plate during that traffic stop, it did show her vehicle was uninsured. I did not confirm or verify that because I wasn't taking action on it. She was receiving a verbal warning for it anyway. But from what I could see in my system, it was showing that her vehicle was uninsured at the time, which she did receive a verbal warning for, in addition to the tinted license plate cover that she had.
Okay, now can I speak?
Yeah.
Okay, so I have another vehicle that was registered under the same plate. So I guess in transference, the state probably didn't have it updated, but I definitely had insurance. He never asked for a copy. So to say that I got a verbal warning, he never asked for my insurance to see if I had it or not. So I don't know how, because I had proof of everything. I made sure of that. I don't drive a vehicle without having proof of insurance. I couldn't take that car off the lot without proof of insurance. The only thing he asked me was that car mine. And I said, yes, this car is mine. It's insured in my name, and I am the only owner. I never got a warning about anything with insurance because we never discussed my insurance because that was the issue. The only thing that officer stated to me was that because I asked him when he pulled me over specifically because I was praising God. I was in praise and worship listening to a Pacific song. And I asked him, I said, excuse me, can I ask you why I'm being pulled over? Because I thought I was following all proper protocol. I knew my car had been registered. I knew that I had just transferred it from another vehicle off the plate at the dealership. They said that I could use the same plate and everything was properly done. I had all that proof in my glove box. I had my insurance. So I knew I wasn't being pulled over for those reasons. So when he said my seatbelt, I was shocked.
Ma'am, did you hear me? I was trying to stop you. Why weren't you stopping?
I didn't hear you say ma'am. I hear you now.
Okay, good. All right, so listen. That insurance, I don't even need to hear about it. I don't need to hear about the tinted window. He didn't write those, but you're responsible of seatbelt violation. I'm sorry. I find you responsible $65. Can you pay that today?
No, I cannot.
When can you pay it?
I don't, I'm unsure.
Where do you work?
At a hair salon.
Well, you got to give me a date when you can pay this, ma'am.
Am I able to fight this further? Because I don't agree.
Yeah, you can pay.
Okay. Well, I would like to do that because I don't agree.
Ma'am. Anybody listening to this knew you weren't going to agree. Hang on.
All the people that I work with feel like it was petty. All the people that I work with feel like it was petty. And even
Young lady, do not interrupt me. Do not interrupt me.
Am I free to speak or not?
No, you're not. I've already heard you. I heard everything you had to say. I'm not about to argue with you.
I'm not arguing with you, sir. I'm an adult just like you are.
A question, and I'm going to tell you the answer. You can appeal this decision. You have to post the bond. Is it 7 days or 14 days, Lisa? Remind me.
I believe it's 7.
May 1, you have to pay by, and you tell them, I want to appeal that decision. You pay your $65, and then they will set it in front of the other judge, and you can tell the other judge your story, and maybe she'll agree with you. I don't know what else I can tell you.
That's all I need to hear. You don't have to tell me anything else. You have a wonderful day.
By May 1. Good luck to you. Thank you.
God bless you.
Thank you. Devon Michael Huff.
Thank you, Your Honor.
What is happening in this world? People think they can argue about everything. Devon Michael Huff.
Thank you. And then on Miss Jallow, Your Honor, this has gotten quite complicated because I did go over the guilty plea form with Miss Jallow back in September. She's here for sentencing. I maintain that I very clearly explained what the agreed recommendation would be, but Miss Jallow is saying she didn't fully understand that she would have to follow through with recommended treatment and has a lot of reservations about that. And I think she has expressed that she would like to just address the court herself and express her wishes regarding sentencing. And that was sort of where the conversation was left off because, yeah.
Okay, Ms. Jallow, do you mind unmuting your device, ma'am?
Yes.
Okay, so Ms. Jallow, your case is 2A58923. You entered a guilty plea on
September 20th, Your Honor.
Yes, September 20th, 2023. It looks like I went over that with you, and then we set sentencing over. Okay, I'm looking at the plea form right now, and it says no criminal law violations. This is the recommendation of the parties. No criminal law violations. Alcohol and drug evaluation. Don't go back to South Center Mall. Obtain a chemical dependency evaluation and complete whatever treatment is recommended. That was entered, and I accepted that guilty plea. So we're on for sentencing, and presumably you've had that substance abuse evaluation. Am I hearing that you have not done that?
No.
Is there a particular reason?
Sorry, Your Honor, I didn't mean to cut it. We've continued this set over sentencing a few times for Miss Jallow to get the evaluation. And she has expressed to me that it's just at this point something she is apparently unwilling to do. And so I'm a little bit, yes, I'm not sure how to proceed.
Thank you. Ms. Jallow, why don't you come on camera? I can't see you.
Yeah.
Ms. Jallow, are you telling me that you're just you're gonna disregard the court's order?
Well, I don't want to do it. I thought my thought on the deferred sentence is that if I didn't do it, I just didn't do it, and it stayed on my record, I didn't know that I have consequences.
Now, Ms. Jallow, I went over the plea form with you. I know I am thorough in going over the plea form. So I'm certain I don't even need to listen to the audio because it was me who went through the plea form with you, not a pro tem. I'm looking at some of the other cases. So you now have, sorry, the system is moving a little slowly.
Just for some background, Your Honor, we were initially trying to negotiate with the Burien matter, and we were going to dismiss one of the two cases if she got into drug treatment in another one. So I'm pretty sure she was aware that that was on the table.
And you also now have a pending assault in the fourth degree domestic violence, assault in the fourth degree charge where it looks like there's some kind of ordered effect out of Kent. And the Kent, am I reading that correctly? You look at me like you're surprised. The Kent court had ordered you not to possess or consume any alcohol or non-prescribed drugs for some reason. I haven't seen that report. I don't know what they're alleging in that case, but you also have an 82423 PC controlled substance violation. So my question is there a particular reason that you have not gotten the substance abuse evaluation? Because that's what the court ordered.
I guess I'll go do it, but I'm just not getting complete treatment. I just know I'm not. I mean, I didn't know that I had consequences if I didn't do it. I thought that it just stayed on my record.
The consequences is that you can get up to 364 days in jail for this. This is a criminal offense, and the parties asked to send sentencing over so that the court can get a copy of a substance abuse evaluation so the court can determine what the appropriate sentence is. The court's not bound by any recommendations that the parties are making. The court doesn't have to follow through with any recommendations. And I thought it was perfectly reasonable, all things considered, for you to go get a substance abuse evaluation as the parties had recommended. So if the city is recommending a 24-month deferred sentence, that doesn't mean I have to follow that. In fact, you failed to appear in this case. You have bail posted. You're now telling me that you don't want to go get an evaluation. What is the motivation?
I mean,
for me
obviously,
to say,
I
okay, this
accidentally
is gonna be
forgot court.
dismissed?
As soon as I found out that I missed court, I went down there and I paid for the bail. If I would have known I had court, I just, I have other things going on in my life, So I mean, it wasn't like I ran, I didn't want to go to court. Do you think I wanted to go pay $500 to get bailed out on this charge? I accidentally forgot about court. People make mistakes in life. Sorry, I'm not perfect.
Well, I think that's what the parties were telling me by saying, yes, people make mistakes in life, so give someone a chance. So go get a substance abuse evaluation, follow through with a treatment recommendation, and have an opportunity to get your case dismissed. You don't have a clean criminal history. You have criminal conviction. So the recommendation for a deferred sentence by both of the parties is rare for someone with a criminal history. So there's obviously something between the parties that they've discussed about you that warranted that recommendation. So I haven't yet followed that recommendation. I need reason to follow that recommendation. It would be perhaps you're going to do something to resolve any issues that these lawyers know about that I don't know about, and have the benefit of the dismissal. I absolutely
And I don't
agree
think
with you.
that the fourth degree assault should be brought up.
I'm sorry,
that
Ms. Jallow.
you don't know the circumstances behind that.
Ms. Jallow, you've been charged with a crime. My job is to look at your criminal history. You have been charged with a crime. City has found probable cause that you've charged with a crime. It's still pending, but the bottom line is you've now been accused of a substance law violation.
I'm not going to be
Violation of your
charged with
conditions
it.
of release. I'm sorry?
It didn't happen, so it's not going to. That shouldn't even be brought up.
Ms. Jallow, I
I'm not guilty of it.
I appreciate that you're trying to think that you know how I should be doing my job, but that's not how it works. The bottom line is, and if you're going to go off camera, you have to come on camera. Otherwise, I'm not going to allow you to be.
Okay, what do you want me to do? Okay, I'll go get the drug and alcohol evaluation. I'm done with this. I'm done.
Person from now on, and I'm setting sentencing over, and you have to get a substance abuse evaluation between now and that sentencing hearing where you have to appear in person. Okay? I'm not going to allow you to be able to control your court hearing by just removing yourself from the screen or interrupting me. You must appear in court in person in 30 days after having that substance abuse evaluation. Do not miss your court dates in Kent. Because I don't want you to have a warrant. And then we're going to see, based on that evaluation, what the appropriate sentence should be. Hopefully still get that deferred so you can get that case dismissed, but then it'll at least have a professional tell me if treatment is appropriate for you. I mean, we don't want to be left guessing. I want to hear what a professional says. So in the course between the time that you pled guilty and today, did you have a chance to speak to court services about where you can get this evaluation done?
I know where I can get it.
Okay. You know where to get it. And then here's the thing. When you come here for sentencing, you have to have the results of that evaluation in writing. Normally that does take time. So you need to get this done as quickly as possible so that they can have their part done for you to bring in the evaluation results here to court. They may ask you to sign a release so that they can send it to us directly. That's between you and the evaluator. But when you come back to court next time, you have to have that evaluation done. Okay? Your next court date.
Are we done?
No, we're not done. We're not done. Hello. Your next court date is March 13th at 10:30. Is that a Wednesday, Nessa?
What did you set up?
This is exactly why you are not going to appear in Zoom again, Ms. Jallow. You are going to be here. Is that a Wednesday, Nessa?
Yes, Your Honor, that's a one.
Okay. March 13th at 10:30, you will appear in person at the Tacoma Justice Center for
Okay, I'll see you
sentencing
then.
with your substance abuse. Don't you dare hang up, Miss Jallo, or I will order a warrant for your arrest.
Well, I mean, what do you want me to do? You told me my next court date's March 13th.
What I'd
I'll
like
be
you to
there.
do, what I'd like you to do is act like you're actually in court. This is the reason why you're not allowed to appear remotely anymore. We're going to email you notice of your next court date. If you do not get an email from us by Tuesday, call the court so that we can follow through to make sure that you receive this document. Do you want to speak to your attorneys before you hang up?
No.
Okay, come back March 13th here at 10:30 with the results of your evaluation so we can go forward with sentencing. You now are free to leave. Thank you.
Why are you being so short with me? I'm trying
That's just the way I am. I'm
Okay,
not a nice
well-
guy. See you live December 30th. Have a nice day.
Your Honor, we're ready.
Mr. Bowditch,
Mr.
what do you got, Jeff?
It's an adjournment on this Hall, Your Honor.
Just want to make up, okay? I'm sick of playing shortstop on Team Glitch.
Don't need me. Just adjourn.
She's screaming because she doesn't want to do it. She has issues. She's yelling.
Go ahead and unmute her.
Unmute yourself, Ms. Deja. Sorry.
Ms. Hall, you do not want an adjournment?
No, I do. I think we need to do more discovery because
It's correct, Your Honor. There's one piece of discovery that I'm still waiting to review.
All right. Pick a Wednesday.
Your Honor, how about December 30th, if we could?
Who's that with?
Yeah.
9 a.m.?
Yeah.
All right, that's 9 a.m.
Thank
Ms.
you.
Hall.
over Zoom, correct?
Ms. Hall, why are you on Zoom?
Because my license is suspended and I don't live anywhere near you guys.
I got an Ipsy address.
Exactly, and that courthouse is about 30 minutes from me.
I'm well aware of where I'm at right now, so you'll be here live on December 30th.
Where?
Where I'm at right now.
Which is where?
34th District Court in Romulus. You just told me how far it was. I assumed you knew where it was at.
Yeah, because I've been there once, but when I had a ride, but that's why I did.
Well, get a ride. You got till December 30th. We'll see you at 9 a.m. on the 30th.
But
Wednesday.
why are you being so short with me? I'm trying.
That's just the way I am. I'm
Okay,
not a
well-
nice guy. See you live December 30th. Have a nice day.
But what if I can't make it? I live by
And I'll
myself.
issue a bench warrant for your arrest, man. That's the way it works. You're ordered to be here live on the 30th of December at 9 a.m. And if you're not here, I'll issue a bench warrant.
But they said they were understanding due to the fact that my license is suspended. I don't have anyone.
Ma'am,
to
I'm not
drive me.
arguing with you. I just told you what the rules are.
But the last judge said something totally different. So
There
they
is no
should-
but. There is no but. I'm the judge. I set my docket. I set this one live. I'm giving you until December 30th to find a ride.
You don't give. I don't have anyone out here for me to just
Okay.
find a ride. It will be.
Okay. Then maybe you should be a nicer person. Maybe you would have a friend. Goodbye.
It's not about that. I'm not from here. I don't have.
Goodbye.
Like, why are you?
Jeff, you got anybody else?
No, Your Honor. My apologies.
Oh, it's not your fault she was nasty to our clerks.
I still apologize.
She's probably got a manicurist that comes to the house, because that's a big thing in Ipsy. Those mobile manicurists, I hear about them all the time. They're on Facebook every day.
The fact that you were in an accident in the past on a different road has no bearing on what's happening here.
No, it's because I was rear-ended and slammed into the vehicle in front of me, and it caused me trauma.
Miss Canfield Cadbury, you can hear me, right?
Yes, I can.
All right. This is a citation that was issued on January 10th of this year on US 131 there in Wayland Township. Said too fast for conditions involving an accident. You're here, ma'am, on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or three, you wish to contest this citation. In other words, fight this ticket at what we call informal hearing. What were you looking to do?
I want the hearing, please. I deny responsibility.
All right. Then the first thing I do is swear you both in. You want to go ahead and raise your right hands? You swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth.
Yes.
Yes, sir.
Ma'am, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place, but then after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Yes, can I just state something for the record first before we begin?
Sure.
The only thing that I wanted to state is that I did previously request an adjournment of this because I did suffer a head injury and I am written off from work because of my head injury by a concussion doctor at the neurology center at Bronson. I'm not supposed to be practicing law, so I don't feel that I should have to go forward. But I was told by the court we could not adjourn this unless I wanted to have a formal hearing and skip this process. So
That is correct.
I
If you
wanted.
don't want to go forward today, you can ask for formal hearing. That'll get reset and they'd be compliant with you asking for a date considerably farther out. But for informal hearing, we don't move dates, either by officer or by the defendant.
Yeah, I just wanted the court to be aware that my processing right now is slower. And so I might take a moment to ask questions and things.
That's fine. We have time.
Thank you.
All right. And so with that, Deputy, you want to pick up the narrative somewhere where it makes sense and explain the issuing of the citation?
Yes, sir. So on January 10th, 2025, shortly after 5:04 p.m., we were dispatched to southbound US 131, just south of the 6-1 mile marker on ramp, for one vehicle crashed into the ditch. Upon arriving on scene, we found a single vehicle identified as a 2016 Chevy, red in color, with the attached Michigan license plate of Edward Lincoln David 430, into the right-hand shoulder of southbound US 131. Through investigation, I found that the vehicle was traveling southbound when it had lost control, went into the ditch, and did sustain damage. I did issue the driver and the only occupant of the vehicle identified as Angelique, and I don't know if I'm pronouncing that right, Angelique Camfield Kuiper, the citation for the violation of the basic speed law for driving too fast. I did issue her citation SD 33604.
All right. And Ms. Camfield Kuiper, what is it you wish to tell me?
I would like to cross-examine the deputy, please.
Okay.
And Deputy Earl, how long have you been a deputy for the Allegan County Sheriff's Department?
I've been here for 2.5 years.
Any prior law enforcement experience?
Yes, ma'am. I've been an officer prior to that for a separate agency for a year and a half.
When did you graduate the academy?
I believe it was 2020.
And what?
Ms. Camfield Kuiper, how would this be relevant to your citation?
I think I have the right to ask him his background and experience to determine whether I was going too fast when there was no personal observation.
Then let me just put something on record here. This is not a speeding ticket. It's not accusing you of speeding. You can get this ticket going 10 miles an hour. What it is you have a duty to maintain your vehicle on the roadway. Weather conditions and road conditions are not a legal defense to this ticket. Essentially, the only legal defense to this ticket is I didn't slide off the road. So I'll let you proceed, but what the officer's experience is not relevant. He's not making a judgment call that you were too fast for conditions. He's simply observing that your car left the roadway. That is the only element to this citation.
Actually, Your Honor, I looked up the statute and the statute says exactly, it is under the speeding statute under 257-627 parens 1 that I.
Yes, ma'am, but like I said, if you're going 10 miles an hour and you slide off the roadway, you will still get this citation. It is not accusing you of speeding. It is accusing you of going too fast for conditions. The prima facie evidence of that is that you left the roadway. But you can continue.
I respectfully disagree with the court on that.
Deputy, did you personally observe any of my driving that day?
No,
Did you speak to anybody who personally observed my driving that day?
no, ma'am.
Can you tell me what the weather conditions were that day?
I believe they were cloudy with snow.
Ron, can you tell me where you were when you were dispatched to the scene?
I believe I was in Wayland when I was dispatched to this scene.
Do you know what the distance was that you were away from where my car was?
I do not.
Do you know how long it took you to get there?
I do not.
Do you know if the snow began earlier in the morning and was accumulating on the highway?
I do not recall.
Do you know if it was icy in addition to being snowy that day?
I do not recall.
Did you have an opportunity to review your accident report prior to testifying today?
Yes, ma'am.
Do you recall on your accident report that you wrote there was no ambulance at the scene?
I do not recall.
Would you refresh your recollection if you saw your accident report?
Yes, ma'am.
Do you have that with you, sir?
Yes, I can pull it up.
Could you take a look at that, please, and tell me whether you marked an ambulance was present or not?
Ma'am, can you tell me whether or not it would be relevant, whether or not there was an ambulance there?
Yes, Your Honor, if the deputy can't recall what the weather was, how long it took him to get there, whether it was icy in addition to snowing, and there are errors in the traffic report, it calls into question the veracity in his recollection with respect to that day.
Okay, but ma'am, the relevant sentence would be your testimony of whether, are you denying that you had an accident and left the roadway?
No, Your Honor, but I have
That's
other.
the only pertinent question.
I have other information to present to the court.
Okay, why don't we present it in the form of testimony as opposed to cross-examination, and I'll determine whether or not this line of inquiry is relevant to a civil infraction, ma'am.
Okay. I guess I don't.
Ma'am, let me put it another way. Road conditions and weather conditions are not a legal defense to this ticket. You have a ticket that says your car left the roadway. Do you have any information to present that your car didn't leave the roadway?
No, the ticket, the statutory section says, did I operate at a careful and prudent speed, not greater than nor less than what's reasonable and proper, having due regard to the traffic surface width of the highway and any other condition existing at
I'm infinitely familiar with the statute. Here's the issue. The testimony is that your car left the roadway. That is the prima facie evidence that you were not traveling at a speed conducive to the weather conditions and the road conditions. Ma'am, you can make that argument, but what I need to hear before I make a ruling, is we're getting way far afield of the information I need, is whether or not your car, you had an accident where you left the roadway that day. I have testimony that you did. If you would like to provide testimony that that didn't happen, that would be relevant for this citation.
So none of the road or weather conditions are relevant to this action?
No, ma'am. I sit here all winter, every year, getting this citation. If you have a slide off, even a one-car slide off, you will get this citation. We cannot give a ticket to the road for being icy or to the weather for being snowy. We live in Michigan.
But
People were driving all day long on 131 and not having accidents, but you had an accident. That's why you have this citation. The defense to this citation would be, I didn't have an accident.
Well, I
You
don't.
cannot blame it on the road or blame it on the weather. That is not an option for me to not find you responsible. I would still find you responsible regardless of the weather or regardless of the road conditions. You always theoretically could have been driving differently and not had an accident.
And
Right?
the court is predisposed to a decision on these tickets.
Well, no, ma'am, because I would be willing to hear you say that didn't happen. I didn't slide off the road. But you're not suggesting that or testifying that. You just are going in circles about road conditions and weather conditions. So what I'm saying is I give you an opportunity right now to present to me relevant testimony to my decision of whether or not you had a slide off that day.
The relevant testimony, Your Honor, is that I was traveling at a careful and prudent speed. And
No, you weren't, ma'am. Otherwise, you wouldn't have had an accident.
I
That is the
disagree
definition
with
of
the
careful and prudent, right?
I disagree with the court.
Okay.
If I
So,
may testify,
ma'am-
I would appreciate doing so.
Go ahead.
Thank you. I work in Grand Rapids and I live in Kalamazoo, Michigan, and I was on my way home from work. You'll have to forgive me. When I talk about this accident, it's very traumatic and it makes me extremely upset. I haven't had a citation in over 20 plus years. My last ticket was when I was in my 20s on my way to law school.
Ma'am, again, that's a relevancy issue. It would be unfair of me if I looked up your record and made decisions on this case based upon whether you did or did not have tickets. All I have to do is decide on January 10th of this year around 5:04 p.m., did you slide off a 131 or not? That's the only thing I have to decide. I already have evidence provided from the deputy that did in fact happen. This is your opportunity to present evidence to me that it didn't happen.
Well, I was driving at a careful and prudent speed, which is part of the statute. And just that the fact that my car went off the roadway does not mean that I was not. There were 22 accidents between mine and the hospital the EMTs were taking me to. They told me that. And it wasn't that every single person was driving too fast for conditions. I had just driven. So when I left my office, it took me 20 minutes to clear off my car. I'm very, very careful to make sure that my lights aren't covered. There's no snow on my roof or anywhere else. My plate is visible. I'm very careful with that. And I had just driven through an accident. I don't have a clear recollection, but it was either just at the south end of the S curve or towards Caledonia. And I was being very cautious because I was trying to get home safely and have a weekend with my daughter because her sister was out of the state at a soccer tournament and I just wanted some time with her. And I remember that I texted over the Bluetooth, my staff at the office, and I said, be very careful, the roads are bad. And then I called my daughter over the Bluetooth and said, honey, I'm going to be late because the roads are really, really bad. And I just passed an accident and I'm taking my time.
Ma'am, I'm going to caution you. Did you just testify that while you were driving, you texted?
Over the Bluetooth. It's the voice to text. I do not hold my phone while I'm driving ever. And I always wear my seatbelt. So I let them know that I was going to be later because I was taking my time and being cautious. When I got into Allegan County, the roads were worse and the visibility was lower. And I'm hesitant always to change lanes in that weather because in Allegan County in particular, the road commission's really bad at clearing the roads. I've driven in this state. I've lived in this state my whole life. I know how to drive in the winter and to be cautious. And I was hit on I-94 in 2021. I was rear-ended.
Ma'am, you are telling a very long and involved story that is irrelevant to the decision I have to make today.
I'm trying to explain what happened.
How is anything that you've told me so far going to explain whether or not you left the roadway or not?
Because it tells you how it happened. I was being careful.
No, it doesn't, ma'am.
Driving.
The fact that you were in an accident in the past on a different road has no bearing on what's happening here.
It does, because I was rear-ended and slammed into the vehicle in front of me, and it caused me trauma. And there was somebody that was coming up really fast behind me, probably a truck, I can't remember. Because I get really nervous then when they're behind me so fast because I've already been hit. So I slowed even more and wanted to put my indicator on and checked my mirror to make sure it was clear. And I started to merge over so I would get out of that person's way. And then the slush was pretty deep. It was about maybe 3 or 4 inches of slush between the lanes, and it caught my tires. And there wasn't anything that I could do. I wasn't driving too fast. I was trying to slow down even more and get out of that person's way. Very careful on the road.
Anything further you wish to tell me, ma'am?
Just that I don't think a preponderance of the evidence demonstrates just because I was off the road that means I wasn't driving carefully and prudently. I was even informing people how bad it was and saying to be careful.
Okay, ma'am, so for purposes of informal hearing, I would find that the deputy has met their burden and that you are responsible on this citation. Now, because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing. Formal hearing is in front of the district court judges. It involves the prosecutor's office. But to get to formal hearing, you must do 2 things. First is you must ask for a formal hearing within 7 days of today's date. That window of opportunity to contest this further closes after 7 days. And 2, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
Yes, I don't know how much the ticket is.
I can tell you that. It's either 110 or 135, depending on whether or not they put the accident on there. $135. So if you come in and post that as bond, and then request that formal hearing within 7 days, you'd get another bite at the apple. I will tell you the problem that formal hearing will also be that road conditions and weather conditions are not a legal defense to this ticket, but you're free to exercise your rights. But we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.